session will focus on California law. So you've incorporated your business. You need talent, people with skills. Your business is starting and you have finite resources. Do you recruit talent as employees or as independent contractors? What is the difference and why does it matter? If your company has everyone sign an agreement that each person hired is an independent contractor and your company provides each person with the required federal tax document for independent contractors, does this guarantee that the workers will in fact be independent contractors? These are some of the questions that we hope you will be able to answer when we finish our session. Both an employee and an independent contractor can have the skills and knowledge that your business needs. So which is best for your business? The answer can ultimately depend on how much resources you have. In California, for example, employees will generally cost a business much, much more than using the services of an independent contractor. To keep costs down, this creates an incentive to classify workers as independent contractors. However, having employees also has its advantages, like loyalty and more control. Now, why does the distinction matter? Misclassifying a worker is a very, very serious matter in California, and it could have a terrible impact on your business, not to mention the possibility of going to jail if the consequences of misclassification are also criminal. When you hire an employee, in addition to paying them, you must also provide them with an itemized federal and state tax deductions, that is, a pay stub. You, the employer, are responsible for making the tax deductions. You, the employer, are responsible for paying the tax deductions to the appropriate tax agencies. This means that your business will have to pay to hire staff or to retain the services of an agency to prepare each pay stub for each employee every time payments are made, which could be weekly, bi-weekly, or monthly. Let's look at the mandatory tax deductions that you, the employer, must make. If you look at the screen, you'll see the column on the right, deductions. Go to the column on the left, deductions. Now go to the next column, it says statutory. That provides you with a list of the mandatory deductions, starting with the federal income tax deduction, right down to the California state disability insurance deductions. Those are mandatory. Under that, you have the word other. That category of optional, basically benefits. So by law, they're not mandatory, but as an employer, you provide them to be competitive when recruiting people. So once again, that adds to the business costs. We're going to now move to another type of pay stub. This is for the hourly rate. Again, you see on the right, the box deductions, those are mandated as an employer. And to the left, earnings, you see the hourly, the rate they're paid. Now, contrast those two employee pay stubs that the employer has to generate each time an employee is paid with the IRS 1099 form that your business will have to provide for an independent contractor only once a year at the end of the tax year. There are no tax deductions here. You simply plug in the total annual amount that you pay the independent contractor using the correct category. Sometimes the only parts you need to complete are the left side for identification purposes and category number 3, other, and you are done for the entire year. Let's look at one case to see how the courts have classified certain people as employees versus independent contractors. You will see in the handout on page 2 a list of cases. We will select one. This case will give you a flavor of how to conduct your business so that you keep the classification of the worker that you want and thereby avoid the serious consequences of misclassification. Let's take a look at the Borrello case, which is the third one listed on the left side of your handout. The facts here concern a farmer, essentially a farming corporation, but I'll call it a farmer. The farmer alleged that the laborers were share farmers and as such were not employees because they managed their own labor, shared in the crop's profit or loss, and had entered into contracts that stated that they were not employees. Whether the agricultural laborers were employees or independent contractors mattered because the question was whether they were covered under workers' compensation insurance, which is only available for employees when they're injured. You will see on the handout, page 1, there's a chart of all the benefits and so forth. Now, the Borello court noted that despite the contract and profit and loss sharing, the court concluded that the laborers were employees, stating that the farmer controlled the agricultural operations on its premises from planting to sale of the crops, and instead of direct supervision, used profit sharing as an incentive to achieve its goals. Therefore, the farmer, that happens to be a corporation, retained all necessary control over the work, which could be done only one way. Also, the laborer's work, though seasonal, followed the usual pattern of an employee. Quoting the court, quote, "In no practical sense are the share farmers entrepreneurs operating independent businesses of their own accounts." End quote. The court concluded that the laborers were employees entitled to be covered under workers' compensation insurance. The Borello court arrived at this decision after looking at multiple factors that pertain to whether or not the employer had the right to control the laborer and how the work was done. The burden of proving that a worker was an independent contractor and not an employee rests with the employer. The factors are complex and multi-layered, but they can be summarized as: can the employer fire the worker? And if doing so, will it cause a breach of contract action? Is the worker engaged in a distinct occupation or business? The nature of the work and whether it is done by a specialist without supervision or done under the supervision of the employer. Is the work a regular integral part of the employer's business? Who supplies the equipment and tools? Is the worker or the employer? Has the worker invested in the business in any way by buying materials or equipment? How is the worker paid? Is it by time spent or by job completed? Can the worker delegate and hire his or her own employees? Is there an opportunity for the worker to make a profit or loss based upon his managerial skills? How permanent is the relationship between the worker and employer? For how long is the worker expected to work? Do both the worker and potential employer believe they're creating employee-employee relationships? Those are the factors looked at. By the 21st century, the legal test for determining whether a worker is an employee or not changed a little. However, in instances where the new test does not apply, the Borello right to control test is used, even up until today.
Yeah, and so the new test came about in 2018 in that Dynamex versus Superior Court case that's listed at the bottom here. Dynamex moved slightly away from Borello and laid out what's commonly referred to as the ABC test. So the ABC test has since been codified in the California Labor Code, and it looks pretty basic, and it's the general test to determine whether a worker is independent contractor or employee. As we're going through this, keep in mind, though, that the actual statute's fairly long, and there are a lot of exceptions that could apply. And when you are looking at this for your own company, you need to be aware of all the exceptions and business-to-business exceptions and whatnot that could apply. But in general, the ABC test works where a worker is presumed to be an employee unless the hiring entity can establish A, B, and C. You have to establish each and every prong. It incorporates some of the aspects of Borello, like in the A prong and in the C prong, but generally B is the hardest prong to satisfy for most businesses. And B is the person performs work that is outside the usual course of the hiring entity's business. And as you can imagine, usually when you're hiring somebody to work for your company, it's not going to be for work that is outside the usual course of your business. And so the test really does fall in favor of classifying workers as employees, and more often than not. And I believe that the California legislator purposely took that position and likes to have workers be classified as employees because being an employee comes with a lot of benefits and protections from the labor code. Even if you satisfy all three of these prongs, you still need to kind of go back to Borrello and look at the control factors that Chinye had mentioned to be certain that you're not exerting too much control over an independent contractor. So once you have determined that a worker's an employee, they're entitled to a myriad of protections under the labor code. The basic ones are minimum wage and overtime, things like that. Two very important ones are meal and rest breaks. And Brinker on the right over here, the Brinker Restaurant Corp case and Augustus, both kind of deal with the requirements to provide meal and rest breaks. Really, Brinker is the case that solidified the obligation of employers to authorize and permit employees to take an unpaid, completely off-duty meal period before the 5th hour of work, a 30-minute meal period. And that is kind of the seminal case that is quoted very often when there are claims for the failure to provide meal periods. Augustus is a case that our firm was heavily involved with. It took about 10 years to go to the California Supreme Court, but it confirmed that the 10-minute rest breaks that are required for every 4 hours worked need to be completely off duty as well. At that point, and how ABM had defended themselves, the prevailing belief was that rest periods, because they are paid rest periods, so they're paid 10-minute rest periods, that there could be some modicum of control over the employee while they are working or while they're on their break. But Augustus really said, no, it needs to be off duty. And that is the rule to this day generally, is that you need to provide off-duty 10-minute paid meal breaks. So another aspect of having employees is the obligations and responsibilities that arise for documentation. Generally, best practices are to create these records and keep them for at least 4 years. Failure to document certain things, if you look here below at that furry case, if things are not documented, like hours worked, meals taken, it creates a presumption against the employer. And what it does is it really means that if an employee brings a claim against you at some point and you have no documentation, the employee can essentially prove their case by saying they worked so many hours or they never got their breaks. And you, as the employer, would have to come up with the evidence to rebut that, which is really difficult to overcome at that point. And so if you look up at the top, there's some mandatory wage and hour documentation. Some of the basic ones are like the Labor Code section 2810.5 notice, which is a California prepared form that gives notice of like wages, the hourly rate and overtime rate and whatnot. Time records are very important. Like I said, they need to show when the employee begins and ends each work period and generally track meal periods. And as Chinye had gone over prior, you need to have itemized wage statements as well. It's recommended that, at least I recommend to all my clients, that we have off the clock work policies and meal and rest break policies, just so that the employees cannot claim that they didn't know that they were entitled to certain rights under the labor code. Right here. Oh, one last thing I was going to mention is if you grow your business relatively quick, as soon as you get over 5 employees, and if you get higher than 5 employees, you need to start looking at the requirements for certain policies and whatnot, because as companies grow in California, you get a lot more obligations put on you. So here I have a sample daily timesheet. If you look at it, it's this pretty basic one that a small company would generally use. It's handwritten. It tracks the start time, the lunch breaks, the end time, the net hours. If there's reimbursable expenses, you have mileage and whatnot. And at the bottom here, this one has a certification that the employee took all their breaks and was not injured during that work period. And it's generally a pretty good sample of at least the basic requirements. As a company grows, or if you have like a payroll provider, you might be able to start tracking this stuff through an app on the phone or some other technological means instead of writing it down.
We have given you a snapshot of the law as it is today. In California and in many other states, the law can change overnight.
So one example of that is the Augustus case that I was talking about just recently. After we won that case, the security company lobby essentially lobbied in an exemption for security companies for off-duty breaks. The same thing happened with ambulance companies. They were able to get a proposition passed which exempted them from having to provide off-duty breaks. So, all aspects of the labor code generally has some sort of exemption or industry-specific rules.
You remember the 3 questions we started with? We hope that you can now answer them for yourselves. The questions were, do you recruit talent as employees or as independent contractors? What is the difference and why does it matter? And then the last question was about whether having a contract will prevail over the facts of the relationship. Bye for now.
Thank you.
Thank you very, very much. That was great. There was one question that just came up around, I think it was from Samantha. Samantha, are you there? Do you want to respond to that if you haven't had that answered yet?
Yeah. So AB5 is what codified the ABC test. I am not generally a fan of it. It kind of was an upheaval when it came out. I like the control test better. The ABC test is really difficult to satisfy for independent contractors, and it leaves a lot of open questions. I also dislike the piecemeal way that it came about. I mean, if you look at it, they came out with like a general employment test for the ABC test, realized that it essentially classified everyone as an employee, even traditionally independent contractor type workers. And then so instead of kind of revising the test, what they did is just add massive amounts of exceptions for different industries. And I just think it to me, it's not the best way. I think it was a good idea that kind of backfired. And now it's just something we got to deal with.
I tend to agree with Trevor on that. And the problem is that B that he mentioned, the B test, that is the trigger for the multiple exceptions that have been created, which means that even if you know the law, you now have to look up a list of so many exceptions and so forth. So that's a big problem for that aspect of the law.